Just keep your arm right there.
Oh, I'm sorry.
Okay, that's okay.
Try not to.
Breathe.
What's that?
I'm having you breathe.
I'm good.
Okay. No. Okay. Just get orient yourself just to your space.
I got an extra legal pad.
No, that's okay. No, I don't want them bumping into our reporter. And just
Tell
want
me
you
when
to
I
be-
can start, Your Honor.
Yeah. Everybody ready? All right. You may commence your cross-examination of the witness, Mr. Lewin.
So, Mr. Durst, Mr. DeGuerin called you Bob. So you tell me, how do you want me to refer to you? I'm comfortable doing it however you want to do it. Do you want me to call you Bob? Do you want me to call you Mr. Durst? What would you prefer?
How about sir?
Okay, I'll call you sir. All right, sir. So, first of all, how do you feel this morning?
Inmates who are going to be transported to court are woken up at 4 a.m. I am always tired.
I got up a little earlier than that, so I can totally understand. As you sit here, would you say, are you nervous? Is it a sense of anticipation? How do you feel?
I feel relieved that I'm finally getting close to getting this over, and I feel nervous, of course.
So it seems like by the answers that you gave, some of them on direct examination, it seems like you've been waiting for this cross-examination for a long time. You said, for instance, during your direct examination, at times you would almost seem bored, and then you would make comments about my questioning you. So I'm just kind of wondering, when you were saying the comments, for instance, that you objected to one of Mr. DeGuerin's questions on relevance, you asked him to ask me what questions I wanted to ask, were you being just humorous, or I was just trying to understand that?
I don't understand the question.
So let me break it up. So during Mr. DeGuerin's direct examination, as an example, you objected to one of his questions under relevance. Do you remember that?
I remember there was a time I rejected something based on relevance. I don't remember what it was.
Right. No, it's kind of unusual. You've been in a courtroom a number of times. It's unusual for a defendant to object to a question from their own lawyer. So I was just trying to understand, were you just was it humorous, or what did that mean?
That was my sense of humor.
And when you also asked Mr. DeGuerin to ask me what questions I had, was that also your sense of humor as well?
I don't remember asking Mr. DeGuerin to ask you what questions you had.
Have you spent much time thinking about kind of what your plan is for how you're going to handle my questions?
Yes.
And in terms of the plan that you've kind of thought about it, what have you decided your approach was going to be?
I don't think I have an approach. I don't know what approach means.
So I can't tell you how much time I've spent on this, but I've probably hundreds, if not maybe 1,000 hours getting this.
Sustained.
So, sir, as you sit here right now, I've got an outline that's roughly 200 pages, and the question that I have for you is, this outline is designed to go through every inconsistency, every lie, every important, if I can finish
Sustain.
the question.
No, sustain.
So my question to you, Mr. Durst, is, as you sit here right now, is there any approach that I can take with you that will encourage you to maybe provide more information than you have so far?
Object the former question.
Sustain.
All right. You understand, Mr. Durst, that there are certain rules for witnesses when they testify, correct?
I understand that there are certain rules. I am not that familiar with what the rules are.
Well,
Specifically, well,
go ahead. I'm sorry. I thought you were finished. I interrupted you.
specifically, there seems to be a very thin line between when someone is making a speech, giving more information. I can't think of a word the lawyers use. When someone is giving more information than the question calls for, there is a word that is repeatedly used that the witness is not allowed to, in essence, tell a story.
Right. So you've been in front of Judge Wyndham now for approximately, it'll be 5 years in November. You've gone to a number of hearings and been in court repeatedly. So you understand that you are supposed to answer the questions that are asked and that you cannot simply add things that either are
Formal question.
No, this is helpful.
not responsive to the questions or are things that Judge Wyndham might have ruled that either you can't talk about or I can't ask you. You understand that, right?
Yes.